here today in Jersey City with Mr. Vince Ansetti, the attorney for Bill Dorrity, for William Dorrity. And I just happened to grab you, Vince. You're dashing out the door, and we just wanted to hammer down a few points in Bill Dorrity's case. He's being, as it was explained to me, he's being taken to court by his landlord. His landlord is taking him to court to evict him for a groundless reason. As it was explained to me in our conversations, the landlord says that Bill let people into the building. And the bottom line is there was a person who gained entry into Bill's building. Bill didn't know about it. When he found out that person was in the building, he called the police. So to have the landlord evict him for this is just groundless. So Bill knows he's going to win, and because he's going to court, he thinks this is a wonderful opportunity to establish some case law to meet four really good objectives. So this has happened to Bill before. He's been taken to court before. Why is this landlord taking him to court for these?
I think it's another frivolous attempt, frivolous cause of action by this landlord for trying to get rid of a tenant's rights advocate that's there to protect the tenant. And someone that's shown the leadership in this building to stand up for their rights. And obviously this landlord doesn't like it.
Okay, so you feel that this is a retaliatory gesture by the landlord?
Well, we've been in, you probably know, we've discussed this, but you know this as well as I do. We've been in court on multiple occasions in the past on these kind of meritless, frivolous actions from it by the landlord, and we beat them before, we'll beat them again.
Good. So Bill is using this opportunity to establish case law, and he's got four objectives, and those objectives are to get independent cameras in the courtroom, to when he wins, he's going to be asking the judge to award him attorney's fees. So he's going to be asking as a tenant for his right to recover attorney's fees. He's going to be asking for enforcement of truth in renting laws. He was not provided with the truth in renting booklet as the landlord is required to give him by law. And you astutely pointed out that it's not even posted in the building, and it should be. And Bill is using this opportunity to ask on a local level and to support a statewide effort by New Jersey State Senator Brian Stack to have security guards in the courtroom. And I should also mention that Brian Stack has proposed a new law. This is New Jersey State Senator Brian Stack that would allow tenants to recover attorney's fees. Is all this correct?
That's correct, and I can address one by one if that's something you want me to do.
Sure.
The truth in renting laws, if they were enforced, there would be a $100 fee per tenant on the landlord for not providing this booklet. If this booklet was provided, their tenants would know their rights, be able to defend themselves. I would defend their rights, as they should. And this building in particular, there's 300 units, right? So at $100 a piece, it's $30,000. The city would benefit from that. The tenants would benefit from that because they'd know their rights. They would be enforced. The landlord would be punished or sanctioned against the landlord, and it would compel them to do the right thing in the future.
So the city of Jersey City could actually raise $30,000 in revenue from one building just
they enforce the truth in renting. They would.
Very good. When you win, Bill is, and there's no question you're going to win, you're very confident that this is a groundless action.
We're very confident. Yeah, we're going to win.
Okay. So because, it's not Bill's responsibility as a tenant to let people in the building or not let people into the building. He is not a security guard. So when you win, you're going to be asking the judge to award attorney's fees to Bill so that the landlord can't use these frivolous actions to keep milking Bill for attorney's fees. Well, I'm not trying to be critical, but
true.
In my case, and I don't mean to drag me into this, but in my case, I was living in a building with 3 other families. They could not afford attorney's fees, and they couldn't get legal aid to take their cases, so they were literally driven out of the building because they couldn't afford to keep going to court with frivolous action after frivolous action. This is a tactic that some landlords use against tenants. So Bill feels that if he can establish as case law that when he wins as a tenant, he gets to recover attorney's fees too, that's another protection for tenants. Is that correct?
I think the first step would be the inception of the lease. If tenants would review it, they would see that the landlord is entitled to receive attorney fees if they prevail for their prevailing party in action against a tenant for, say, non-payment of rent, which makes sense, and that's understandable why that's in there. However, on the flip side of it, there is no provision in any of these leases that I've ever seen that least in New Jersey, that affords a tenant the right to collect on attorney fees for money they spent out to protect their interests and their rights in a landlord-tenant action. So, if you don't mind to go further on that, elaborate on that. If one, the tenant should review that lease at the inception, and then in demand or insist that that provision of similar to that be implemented into the original lease before they sign it. So that's number one. Number two, in this case in particular, obviously Mr. Dorrity has been in the premises for a significant period of time, so he didn't have those. He wasn't advised of that when he entered into this lease. So what we're going to do is we're going to request from, or demand for that matter, attorney fees from the judge in this case, and Judge Marin in landlord-tenant, based on this frivolous action brought by the landlord, as we have in the past, and we will continue to as these in the future, if these types of actions or cause of action are brought against Mr. Dorrity.
So right now, Bill's lease is written to protect the landlord. If the landlord wins against a tenant, he would be able to ask the judge to recover his attorney's fees, but all the leases in New Jersey don't have that language to protect tenants. So what you're hoping to do in this case is to even the playing field so that tenants can recover attorney's fees, and you're trying to get basic fairness for tenants. So that, and you're asking tenants to look at their leases, and if your lease is written that says, and all leases are in New Jersey, if the landlord wins, he can ask to recover his attorney's fees, he can ask to be made whole again, and the same protection should be put there for tenants. We shouldn't have leases drafted where one party gets all the benefits and the other party doesn't. We should have basic fairness, a level playing field. And when you get this for Bill, you will be establishing case law. This is why you're a great big hero. You will be establishing case law that New Jersey State Senator Brian Stack can point to or reference to, because he's proposing a new law on the state level that would give tenants the rights to recover attorney's fees too, as a basic fairness issue. Is that correct?
It is correct, and until legislative movement is passed, I think tenant awareness is most important. Hopefully, and we can all push for this legislation to go through, where it becomes that each lease, every lease out there should, you say, even the playing field. I think that's a good expression to use, that both tenants and landlords should be afforded similar rights.
Absolutely, because the ability to pay for an attorney should never be a bar to justice.
Well said.
So far what you're driving for is enforcement of truth in renting laws, tenants' rights to recover attorney's fees too in successful action against their landlords, and you want independent cameras in the courtroom. Bill has invited me there because, again, well, first of all, we should preference our remarks by saying a precedent has already been set in the state of New Jersey by the Jersey Journal. They went in and filmed Mayor Healy's case. So Bill has invited me in to film his case. And one of the reasons he wants independent cameras in the courtroom is because it protects the integrity of the process. It's not unheard of that you can manipulate a judge, that you can manipulate attorneys, that the transcript could be manipulated, and you could, in order to protect from the potential corruption of the courts and protect the integrity of the system, Bill wants independent cameras in the courtroom.
I think in addition to protection of the integrity of the judicial process is also, there's elderly, there's disabled tenants out there that are in this building in particular, 3060 Canyon Boulevard, that will never have the opportunity nor the means to be in the courtroom, to see what happens. And I think, again, that's one of the most significant benefits to having cameras in the courtroom.
And that's an excellent point, because Bill's building is made up solely of disabled people and elderly people. They can't get to the courtroom. They should be able to see what's going on. Okay, so thank you so much. We're driving forward these the four objectives in Bill's case: independent cameras in the courtroom, tenants' rights to recover attorney's fees, enforcement of truth in renting laws. And that booklet is supposed to be provided both in English and Spanish. And Hudson County is.
It's a perfect example where it should be in both.
Hudson County is 40% Spanish, so that information needs to be in both English and Spanish. And Bill is using this case to ask.
I'm going to go to the fourth point, and I apologize.
Go ahead.
That I was talking to you about was the security guard. I think that I think it's important for the audience to realize that in this particular instance, there's a landlord that doesn't provide a security guard from other than from 10 p.m. to 6 a.m. in 3060 Kennedy Boulevard, for example. Those other 16 hours, which is one of the reasons, maybe the most significant reason that the landlord is bringing these allegations again, utilizing that what you had already mentioned, that someone was let into the premises, say without permission, but that's their allegation at least, right? Mr. Dorrity didn't have the permission to allow somebody into the premises.
But he didn't. So somebody came in.
Well, you know what? If there was a security guard there, they would have been restricted from access anyway. But that's beside the point. In this particular instance, he didn't. He called the police when he found out the person was already in the premises. However, again, using Mr. Doherty's case, the person's up on the 16th floor already. Mr. Doherty didn't let him in.
Right.
But he's already up on the 16th floor, and they're casting blame on Mr. Doherty, obviously. But that's a landlord's maybe their means to try and get rid of, obviously, again, we talked about earlier, is the tenants' rights advocate in their building, causing them, in their mind, a problem. They're utilizing this scenario as an opportunity, right? This would never be before the courts are even discussing this today if there was a security guard 24/7. And the way that would happen, and I know that you had mentioned to me, I think, doing your investigative research, was that in other cities and counties, they have
in Newark, for example, they had real life experience. We went and asked the tenant leaders in Newark, and they said the tenants in Bill's building are operating under the misapprehension or the disinformation that they believe that if they had security guards 24/7, that their rents would go up.
Increase. Yeah, I've heard that before, and let's use this particular building at 36 Kennedy Boulevard. Approximately 300 tenants in this building. The 16-hour gap where there is no security guard at the front desk. Even if you take worst case scenario, you're looking at $48,000 to $50,000 a year in salary for security guards to be there 24/7. Worst case, you're looking at say $10 to $13 increase in rent. Obviously, legislative movements to ensure that tenants won't have to pay any additional rent is certainly in play right now, but until those get passed, the worst case, we're talking about $10 to $13, not hundreds of dollars, which you had mentioned to me.
Bill's landlord is trying to scare the tenants into believing that if they had 24/7 security guards, that their rents would go up $100, $200, $300 a month. That's not true. First of all, it's a purely theoretical argument, and the worst case purely theoretical argument, by your calculation, maybe the rents would be increased up $10 to $13 a month, which is nominal. But the real world experience of tenants in Newark over a 2-year period, I think a 27-month period, when the landlords were forced into compliance to provide security guards, was that their rents did not go up, their quality of life got better, crime was reduced, the police were happy with the security guards for lots of reasons. So actually the landlord benefited by having 24/7 security guards. So one of the reasons why Bill is out there trying to give out trying to combat this disinformation campaign is that it's not true. The rents in the real world experience of tenants in Newark, New Jersey, rents did not go up when buildings were forced into compliance with 24/7 security guards. And we even got a statement from one of those tenant leaders, Eric Martindale, said that's not true. So for lots of reasons, Bill feels that even though he's being taken to court for a frivolous reason, somebody gained access to the building and now the landlord is blaming Bill, when in fact Bill's the guy who called the police and said this guy shouldn't be here. So now he's being taken to court with this retaliatory gesture, and rather than being upset by it, he's a hero. And he's saying, this is a marvelous opportunity for me to meet 4 really good objectives that we've discussed a little bit today. So let's just finish up by reviewing those. Bill is going to get independent cameras in the courtroom, and thank you, Jersey Journal, for already setting that precedent. He wants to establish a tenant's rights to recover attorney's fees too. He wants enforcement of truth in renting laws as a tool to raise revenue to help the city help tenants. And he wants security guards in the building. Those are your 4 objectives?
I think in this particular case, I think those 4 objectives can be not only brought to light, but accomplished. So yes, those are our 4 objectives.
Terrific. Thank you so much.
Thank you.